Hello, we're going to continue our military blog series in family law matters today with a kind of a look back on the Servicemembers Civil Relief Act. We'll refer to it as the SCRA. The SCRA is kind of a bedrock principle that's going to address significant issues in a family law matter involving a service member. I'm going to go through a little bit of the brief history of the SCRA and then determine who it applies to and how it applies, since it's an extremely important federal law that governs every single military filing involving A, active duty service member, B, and mobilized reservist, or C, National Guard. So those are the three categories of service member. Pretty much governs anybody in the service at this point, and family lawyers and their clients need to be aware of this important act. So a little bit of the history involved, very briefly. The SCRA was first passed right around World War II and updated again twice, first in 1991, then in 2003. At the time, roughly, of both Gulf Wars. What is the purpose of the act? The purpose is to permit the service member, when a civil suit is filed, to address that suit, but to have some relief from the distraction the suit causes if it will interfere with the service member's duties. Keep in mind, one very important issue is that the SCRA does not apply to criminal actions, criminal cases. It only applies to civil cases. So family cases, including divorce, child support, paternity actions, guardianships, things of that nature, are considered civil cases, and therefore all of those type of actions are governed by the SCRA. So again, the act is designed to prevent distractions from the members' duties if they are active duty or reserve, etc. And there's a specific provisions that have to be followed in the act by both parties to make sure it's applied appropriately. So keeping with the concept of what the reasoning is behind the act, there are many service members who are not deployed on a domestic base. For example, there may be service members overseas in combat. There may be service members on secret missions or on a submarine where they're gone for months at a time. And therefore, once a civil suit is filed in the U.S., the service member A may not receive notice of it in the time period required under the civil laws, and B, even if they have notice, may not be in a position to participate or even respond to the suit. So the SCRA initially grants a 90-day stay of proceedings, stay of the case, to allow the service member time to respond and perhaps get an attorney. So a stay is a formal pause in the whatever the civil case may be. Let's take a divorce. A divorce is filed, and the service member finds out about it, files the appropriate request under the SCRA, and the divorce case is paused for at least 90 days. And in that period, for the most part, nothing can happen. We'll get to some ways to address that a little later on. But there is a general stop of the case for 90 days. So how does the service member get that 90-day stay? It's not automatic just because one of the parties is in the service. So what happens is the service member has to file a request that lists four things. First, there has to be an affidavit indicating how the service member's duties prevent him or her from meaningfully participating in the case. Second, the service member has to indicate at least an estimate of when he or she may be available to participate. Third, there must be communication from the member's commanding officer indicating that the service member actually has duties that are preventing him or her from participating. And fourth, the member has to indicate that there is no available military leave that would allow participation in the case. Okay, so once those are filed, then if the request meets all four criteria, a 90-day stay is granted. It is possible to get an additional stays of 90 days, etc., or more, but the same criteria have to be met. The service member can't simply say, I'm in the military, I want to stay. That's not enough. The criteria we just discussed have to be met each time. At some point, the petitioner, whether it's the other spouse or perhaps the other parent of the child, does have a right to proceed with his or her civil case. So at some point, the member is going to be required to participate. It's not going to be, the SCRA is not going to be a means for the member simply to delay a case indefinitely that he or she would rather not deal with. So for example, a service member doesn't want the divorce, he or she can simply file repeated requests for stays that don't have any basis. At some point, the divorce is going to happen and a stay is going to be denied. The member is going to have to make some provisions with his or her commanding officer, etc. So the other thing that comes up in some of these SCRA requests, which again we'll address in later blogs, is the concern about submitting the service member to the jurisdiction where the case is filed simply by filing this request for a stay. The SCRA indicates that that's not a problem. The service member can file their request for the stay without formally submitting him or herself to the jurisdiction of the court. So for example, if the service member's spouse, while he was in service, moved to a different state, filed divorce there, the service member had never been there, doesn't have any connection with that other state, he could file a request to stay the case without, in essence, agreeing that the case will go forward in that other state. So he can still file later on, after he gets legal counsel, an objection to the jurisdiction without having submitted himself to that other state's authority. So this is just a very broad overview of the SCRA. We'll address more provisions of it, both from the service member's position and from the other spouse or the other parent's position, regarding some ways that to challenge a request for a stay or a jurisdictional request under the SCRA. Look out for future blogs on this subject. We're available on YouTube, on our blog, KowalskiFamilyLaw.com. This video blog will be available, as well as other information in written form. We'll talk soon.